Presently, it's not.
Who is the present one?
But now,
Mr. Debojit Kundu, learned advocate for the petitioner applicant, submits that the District Inspector of Schools, AC Kujbihar, has been changed. He seeks to take appropriate steps. He also informs the court that previously a contempt application being CPAN 8 of 2022 was filed. However, since the file was missing, the petitioner has filed subsequently CPAN 64 of 2023. Mr. Orijit Ghosh, learned advocate appearing for the state respondents, seeks that the copy of the contempt application be served upon him. Learned advocate for the petition applicant that will serve copy of the contempt application upon the state respondents. Learned advocate for state respondents. Let the matter be placed before the next available circuit.
yeah.
একটা ভিডিও করবো এখানে কিছুই হয়নি আগে তো লোক অ্যাপিয়ার করো কেন সার্ভিস হয়ে আছে
Item 10 and 11.
Both are the
এটা তাড়ে করো বসে আসছে এটাও দুটো আছে
10 and 11. Item 12.
State is represented, Your Lordship, led by Ms. Radhika Agarwal. Devojit.
You have got the instruction?
Yes, Your Lordship. This is regarding overdrawal, Your Lordship.
File the instruction.
Your Lordship, this is addressed to the learned advocate, to the court, Your Lordship, to the state, Your Lordship. So not
What
in a
is the
report
instruction?
form. This is not in a form of an affidavit of the court, Your Lordship. Your Lordship, as per my instruction, Your Lordship.
Yes. Where is Mr. Kundu?
Yes, your lordship. So as per my instruction, she has for the period of January 97 to May 97, she has got extra overdrawn money is for that period because then she was not a trained teacher. So, but the counsel for the petitioner is not present, your lordship.
Also,
The instruction. Wait, let me. No, password what?
13.
If I not done for the petitioner lordship, this was an dying harness lordship. Earlier it was appeared. The state was instructed to take an instruction lordship.
Familiar. This is common.
My lord, it's relating to the gratuity in area lordship.
she submitted on 12 June.
Yes, lordship.
So there's delay on your part. You did not submit that.
Lordship,
If
this
there is any delay, it will be counted from 12 June 2024.
lordship, I didn't get lordship.
They say that the pension papers were submitted on 12 June 2024, not prior to that date.
No, lordship, but as per my instruction, lordship, we have filed before that, lordship.
When did you submit the pension papers? Show her this paragraph. এটা দেখান তো।
I don't know.
Sure. Lordship, we didn't file annex this paper, but we filed the issue of that on the day of 31st of July 2000 when the PPO was issued, lordship.
But if you have submitted in June 2024, how can PPO be issued on a prior date?
No, PPO was issued on 31st July, lordship. We filed on June, 12th of June. It's July.
Any interest will be calculated from day following the date of your submission of the application.
Yes, lordship.
Ashok. The report filed by the state is taken on record. By the present writ petition, the petitioner seeks for disbursement of interest on gratuity and gratuity in area pension amount at the rate of 18% per annum. The petitioner contains that her husband, late Ruby Charan Narjinari, was assistant teacher of Which school?
Assistant teacher of Mathavanga Girls High School, District
Mathavanga
Coach Bihar.
Girls High School, District Coach Bihar, who died in harness on 22nd March 2022.
Lordship.
The pension payment order was issued on 31st July 2025.
Right.
Stop. The gratuity and arrear pension amount was disbursed on 4th August 2025. However, no interest was paid. Hence this writ petition. The submission the same. Mr. Arijit Ghosh, learned advocate for the state respondent, submits that the petitioner the husband, isn't it? You can wife, no? Husband is the petitioner.
Husband of the
The wife,
petitioner.
the wife,
Wife is the applicant, Lordship.
wife.
Wife. No, Lordship. Lordship, I'll be corrected, Lordship. The wife, yes,
Wife
The-
or husband?
husband is the applicant. Wife was the,
No, Robi, Robi
Yes.
son.
wife of the petitioner, Lordship.
Lokhi Kanta Narjari. For this, the petitioner contains that his wife was an approved assistant teacher of Mathavanga Girls High School, District Coach PR, who died in harness on 22nd March 2022. Baki the same. Mr. Arijit Ghosh, learned advocate for the state respondent, submits that the pension payment order could not be issued just after the demise of the deceased employee, since the petitioner himself submitted the pension papers only on 12 June 2024, after a delay of 2 years, 2 months. As such, the petitioner is not entitled to interest on gratuity and arrear pension. It is found from the report of the state that the petitioner, being the husband of the deceased employee, submitted the pension papers through the head of institution only on 12 June 2024, after 2 years and 2 months. On receipt of the pension proposal, the case of the petitioner was processed and the pension payment order was issued on 31st July 2025. It appears that there is delay on the part of the petitioner in submitting the pension papers. Accordingly, this court of the view that the petitioner is entitled to interest from the date following the date of submission of pension papers till when it was paid,
It was paid on 4th of August 2025.
till actual disbursement of the amount on 4th August 2025. Accordingly, it's disposed.
Grateful, Lordship.
May I please your lordship in item number 4? Am I audible now, my lord?
Fourteen.
14, Lordship, matters pertaining to the overdrawn, Lordship.
Overturned.
It is overall instruction.
Lordship,
Matlab,
yesterday also they
Did not
gave for
receive the instruction,
Lordship.
but I do not find any document which shows that this challan has been communicated, information has been communicated to the DI so that he can process.
13 to 14, 22 to 24. When did he retire?
He retired on 31st of March 2024, Lordship. She, Lordship.
31st of March.
31st of March 24, Lordship.
This is also 18 June 24.
Yes. Now there's a two-part payment has been made. First, the payment of deposited on the 18th of June, and the second payment was made on 26th of November 2024.
What is the total amount?
Total amount, Lordship, is 49,000 something, Lordship.
The affidavit of service filed on behalf of the petition is taken on record. Challan is there, no? 19
Yes, yes,
and
Lordship.
20.
In annexure,
You
both the
find it on
challan is
19
there.
and 20 challan is there.
19 and 20 minutes.
Yes, challan is there.
Yes, yes, Lordship. In page number 19 and 20, yes.
File the affidavit of service. By the present writ petition, the petitioner seeks for disbursement of refund of alleged overdrawn of salary amount of rupees 4261
Lordship, the total amount is 49,688.
and rupees 4261 and rupees 7057 to the petitioner. The direction upon the respondent authorities for refund of that, together with interest at the rate of 18% per annum from the date of retirement till the date of actual payment. The petitioner contends that she was an assistant teacher of which school?
Assistant teacher of Mona Primary School,
Mona Primary
Tokhana,
School,
Darjeeling.
Post Tokhana District, Darjeeling,
Darjeeling.
who retired from service on superannuation on
31st
31st
of March 2024.
March 2024. The petitioner was directed by the respondent authorities to deposit the alleged overdrawn amount of rupees 42631 and rupees 7057 before the concerned treasury for issuance of or sanction of pension. Accordingly, on 18 June 2024 and 20th November 2024, the petitioner deposited the said amount, aforesaid amounts. Consequently, on 20th February 2025,
PPO was issued.
pension payment order was issued in favor of the petitioner. Such direction for deposit of the alleged overdrawn amount after the retirement is impermissible in law. Hence this writ petition. Submission to same level. Mr. Urijit Ghosh, learned advocate for the state, respondent submits that the petitioner has deposited the aforesaid amount of overdrawn of salary without any demur. And as such, the petitioner cannot claim for refund of the alleged overdrawn amount. He seeks for dismissal of the writ petition. Same question. The only issue which, upon hearing the learned advocate for respective parties, the only issue which falls for consideration is whether the direction for deposit of the overdrawn amount, alleged overdrawn amount by the respondent authorities is sustainable or not. Rafiq Masi Court. It is found from the from annexure P1 and at page 19 and 20 that the alleged overdrawn amount of rupees 42631 was deposited on 18 June 2024 and amount of rupees 7057 was deposited on
26th of November.
26 November 2024.
Four.
Both the aforesaid deposits have been made after the retirement of the petitioner on 31st March 2024. Moreover, the period of the alleged overdrawn amount of rupees 7057 is more than 5 years. 5 years. Accordingly, bearing in mind the proposition laid down in Rafiq Masi Supra, the alleged overdrawn amount is impermissible in law. The same together with interest at the rate of 8% from the date of deposit till the date of actual payment within a period of 6 weeks from date of communication of this order. Next.
Fifteen.
15, Lordship, yesterday there was a Yes, Lordship, there was a mistake in the petition, Lordship. I have taken the instruction from my client. She was a group D staff in the school, Lordship. And it was the district of Darjeeling.
Siliguri.
District, yes, it was written Shiliguri, but Shiliguri is not a district, so it would be Darjeeling.
It will be Darjeeling.
Darjeeling, Lordship.
Which high school?
High school is the same, Lordship. Nepali Kollan Girls High School.
Where is the PPO?
PPO.
PPO group A.
Lordship. PPO page, Lordship, we issued in, yes, Lordship, in the page 13. Yes. Lordship, she retired on 22nd, 31st of August, and the PPO was issued on 6th of July 2023.
What is your instruction?
I did not receive the instruction, my lord.
My lord, on the PPO issued, it was written that the date of service was Group D, Lordship. So it is the Group
But the
D.
school is not reflected over here.
Sir, kindly make it next again, in the meantime, we will take appropriate action. Lord.
Where is the document showing that she was stayed at Nepali Kalyan Girls High School? Where from did you get it?
Lordship, it was an instruction that we received. Lordship, you kindly keep it on the next circuit, Lordship.
On the joint prayer of the parties, list this matter before the next hearing.
Lordship, it's in the department, school education department, but the school name is not mentioned. However, the school name is not mentioned, but it was written the school education department.
It will appear before the next hearing. Next,
Lo-
16.
16 Lordship, it's also pertaining to the overdraw Lordship.
this is of
Overdraw Lordship. On the last day, it was appeared and the state was taking time for take the instruction Lordship.
who is for the state? Mr. Ghosh, you are appearing for the state.
Yes, your lordship.
What is the instruction? When did he retire?
He retired on 31st of March 2025.
March 25.
25 Lordship. He deposited the amount on the 1st of July 2025. He annexed the Challan Lordship. Challan in page number 14, P1.
14. What is the instruction?
Sir, did not receive the instruction, sir.
Dispose it off.
Yes, sir.
This is also after the retirement. Affidavit of service filed on behalf of the petitioner is
Service.
taken on record by the present writ petition. The petitioner seeks for a refund of the alleged overdrawn
3,30,038,658.
3,38,658 together with interest at the rate of together with interest. The petitioner contains that he was an assistant teacher of Deshbandhu Nagar Girls High School, District Jalpaiguri. The petitioner superannuated on 31st March 2025. The pension payment order of the petitioner was not issued in favor of the petitioner and he was directed to deposit alleged overdrawn salary of rupees 3,38,658 on 1st July 2025. The petitioner deposited the aforesaid amount of rupees 3,38,658 before the concerned treasury upon deposit of the alleged overdrawn amount. Pension payment order was issued in favor of the petitioner on
28th of July. 5.
on 28th July 2025. The direction to deposit the overdrawn amount, alleged overdrawn amount after retirement is impermissible in law. Baki submission same. Mr. Ghosh's submission again same. It is found that it is found on annexure P1 that the alleged overdrawn of salary has been deposited by the petitioner on 1st July 2020. On after his retirement. On 31st March 2025. The alleged overdrawn of salary is for the period 1st July 2009 to 31st March 2025, which is also more than 5 years. Bearing in mind the observation of the Supreme Court in Rafiq Masi Sutra, such amount is such direction for refund is impermissible in law. From date of refund was July 2025 till the date of actual payment, 8% within a period of 6 weeks disposed of.
Lord, may I have your
Yes,
lordship's
sir.
kind leave to mention item number 4? Passover, my lord, item number 4, may I be allowed to mention?
Stated the mistake আমরা আছি
Passover,
Sir, will you kindly wait?
Well, I have intimated to Mr. Subhashit, Mr. Vilas, but they are not interested. But kindly make it not today or next again.
Not today. No. Ask him to, he has not come to court.
I have intimated to my junior miss.
Take it afterwards. Photo din.
Court number 5.
Yes. Yes. Now, item number 4.
my lord,
Item 4.
my lord, item number 4. My lord,
Yes.
this is an application appearing for the first time, my lord, for contempt. My lord will kindly turns over to page 165, my lord, and extra B is the order which has been violated, my lord, and the respondents are in contempt of this order, my lord.
Okay.
My lord, has your lordship got the fine, the order?
Yes, yes. Yes.
My lord, may I just place it, my lord? My lord, may I just place the order, my lord? This is an application of Article 226 of the Constitution of India. For sanction of site plan and building plan. As per section 263, 275 of the West Bengal Municipal Corporation Act 2006, read with Rule 4 of the West Bengal Municipal Rules. This is the second third dictated with regard to this premises and sanction plan. After hearing the parties, the court has been able to convince them to come to a mutual settlement. The settlement is being reported as follows: 166, internal page 2 is the settlement matter. The petitioner shall remove the plywood and other materials lying in the premises within a period of 15 days. From date upon such removal, he shall inform the concerned authority, and the concerned authority shall thereof demolish the illegal structure on the premises within a period of 15 days. And upon demolition of the structure, the corporation shall consider the application for the sanction plan of the petitioner in compliance with acts and rules and grant the sanction in accordance with the law within 4 weeks. My lord, now I pause here for a moment, my lord. My lord, B and C has not been complied with, my lord. I have communicated, my lord. The communication is, my lord, will kindly sign. My lord, will kindly takes the next annexure, my lord. Annexure C at 167, my lord. This is my communication, my lord. The second paragraph from the bottom. His lordship, in passing the said order, furthermore directed you to address therefore is the structure standing in the subject premises in a period of 15 days thereafter, and grant the sanction to and in of the premises in a period of 15 days. In compliance with the order, I have stored plywood from my personal effects and other miscellaneous effects from the said premises, so and so, within the said stipulated time in terms of the direction issued by virtue of the said order. Accordingly, you are requested to comply with the directions issued by the said order dated 13/12/2019, passed in WPS so and so, and demolish the structure standing in the subject premises within a period of 15 days. You are furthermore requested to take up and consider the site plan being site plan number so and so, and my building plan being so and so, and grants action in respect of the both of them within a period of 4 weeks thereafter. My lord, this is still pending, and now the most important annexure, my lord, will be, my lord, kindly takes, my lord, page 184. My lord, the response of the municipal corporation, my lord, is the last annexure, my lord, last but one annexure, my lord. 184.
Yes.
Lordship got it. My lord, kindly see their response. My lord, I'm skipping the previous portions. I'm starting from it is further stated. Has your lordship find it? My lord, it will be reference thereafter with reference to the order dated serial number 6 dated so and so. My lord, immediately the next paragraph, it is further stated that on 24th of February 2020, workers and supervisor from SMC went for demolition of the unauthorized structure and started demolition process with material and machines. That it appears the demolition process could not be continued due to COVID-19 pandemic, which was in full swing. In the meantime, there was complete lockdown as well as partial lockdown due to the workers were not available. That the SMC shall begin with the demolition work as soon as possible, probably within 50 days from the applying of local transports and trades. However, you are requested as per the order of the Honorable High Court Jalpaiguri Circuit Bench.
There was a private respondent in the
Yes, my lord.
proceedings. In the writ petition, there was a private respondent.
No, my
No.
no, my lord.
This mutual settlement-
against the municipal authorities.
So the
My lord,
mutual
what
settlement was
I will
between.
indicate that between the municipal authorities and the petitioner. Because, my lord, in the West Bengal Municipal Act, there is a provision of deemed sanction. My lord, if the sanction plan is not considered within a stipulated period of time, the provision is there of deemed sanction that the incumbent who has applied, the applicant for sanction, can proceed with a deemed sanction, my lord. My lord, that was the case here, which has been proceeded with. Now, Lord, thereafter these things have come up, and my lord, thereafter this order has come up. My lord, that was the reason why there was a mutual settlement arrived at to put the list to rest. And my lord,
Okay.
these terms were
You are for the
dictated, my
corporation?
lord.
I'm appealing for the Shillong Municipal Corporation, Lordship.
So
Our
fine.
decision order has been passed and challenging that decision order, they have filed a fresh petition which is pending adjudication.
Then-
In that petition, there was a direction
My
for
lord, that
filing
is
of
not with
affidavit
regard
of
to this, my lord. That is a separate. My lord, let them place it by way of an affidavit, my lord.
Then kindly direct them to serve a copy of this contempt application upon us. And changing the name of the applicant,
Yes, my lord.
the
I shall serve
contemnor,
it
the
immediately.
Sonam,
Who is the present commissioner?
Mr. WBCS officer Ashwini Kumar Rai.
Ashwini Kumar
Rai.
Naik.
Ray, Are bhai, Ashwini Kumar Ray.
Give the name on the prayer. Sir, who will correct the name of the alleged contemner in Jalpaiguri?
My lord, if your lordship passes a direction, my lord, my on record will carry out the necessary changes, my lord, the corrections that have been directed, my lord.
Who?
My lord, Mr. Shayantan Kaur will do so.
On the prayer of Mr. Deborshi Dhar, learned advocate for the Siliguri Municipal Corporation, informs that the alleged contemner, Mr. Sonam W. Bhutia, is no more the commissioner. The new incumbent is Mr. Dhar, please give the name,
Lordship.
is such and such. At this stage,
আরে ওইটা না সব বুঝে গেল তো হয়ে
learned
গেছে।
advocate for the petitioner applicant seeks for incorporation of name of the new incumbent as the alleged contemner. Leave granted. Huh? Petitioner applicant is directed to serve the copy of the contempt application upon the alleged contemner and file affidavit of service on the returnable date. Release this matter before
My
the
lord, may I just
next
pray for one
available
indulgence
service.
since Mr. Dhar is appearing?
Mr.
May I
Dhar
just
is
pray
not
for an
representing the
indulgence since
commission
Mr. Dhar is
authority.
appearing? My lord,
Yes.
I got it.
No, give copy to the
Yes, my
new
lord.
incumbent and then file affidavit of service
Yes, my lord.
এটা হবে
Yes,
and
my
ask
lord.
your advocate on record to
My lord,
make
in the
necessary
meantime, may there be a-
incorporation in custody. Ask your learned advocate on
Your lordship.
record in the
My-
circuit bench to make
Okay,
necessary
number.
I have followed,
incorporation.
my lord. I have followed, my lord.
Yes, yes,
I have followed, my lord.
yes. Thank you.
Grateful, lordship.
Item 5. Item 5 to be not.
তো এই
নিউ
আছে।
কমিশনার অফিসে বসে
I
আসলে
have personally went to court number 5 and asked
Or is
If
appearance?
he is not coming, then we are issuing
Or
notice to the applicant. Let
Appearance.
the applicant appear. None appears on behalf of the petitioner applicant. 5 to them. Department is directed to issue notice to the petitioner applicant in the meantime. We'll list this matter before the next available circuit bench.
Item 6.
6. Same. Same or
7. And 11. 7, sir.
none appears on behalf of the petitioner. Issue notice to the applicant petition.
Item 12.
Please representative.
It's not relating to overdall amount, but refund of overdall amount. Last question, and the page 16, that is the channel. Prior to the retirement, before 1 month, she deposited, overdall amount. Thereafter, PPO was issued.
Retired on 31st August.
31st August 2025.
Give that report. Give the report.
As per my instruction, this is the communication that I have.
This is wrong fixation.
Yes.
Yes, Your Lordship. According to the DI Kuchbihar, Your Lordship, this was done because there was a for the time span of January 97 to May 97. The present petitioner, she did not have she was not a trained teacher, but for that span she got the salary of a trained teacher, Your Lordship, and as a result, there were subsequent overdrawn on the part of the petitioner.
But the challan reflects that it is 1197 till 31st March 2025.
Yes, Your Lordship. Yes.
Asun. When did you retire? March 23. Deposited on 28th September 20. One is October 23 and another is September 23. Yes, affidavit of service.
Services, I would give enrolled lordship. Services.
Wherever the petition is taken on record by the present writ petition, the petitioner seeks direction upon the respondent authorities for refund of alleged overdrawal of pay to the petitioner together with statutory interest. The petitioner contains that he was a Group D staff of Jitpur Girls High School, District Alipurduar. The petitioner retired from service on superannuation on 31st March 2023. However, the pension payment order was not issued. The respondent authorities, particularly District Inspector of Schools, AC, Alipurduar, directed the petitioner to deposit an overdrawal of pay of rupees 47717 on the ground of wrong fixation of pay. The petitioner deposited the aforesaid amount of overdrawn of pay on 28th September 2023. The amount directed to be deposited by the petitioner towards overdrawn of pay is impermissible in law after his retirement. After his retirement, কতটা আগে দিয়ে দেবেন তো? Is impermissible in law. So and so, learned advocate for the petitioner submits that the amount of the overdrawn has been directed by the respondent authorities to deposit after the retirement of the petitioner, which is impermissible in law to buttress or contentions, it relies on the decision of such and such. Mr. Twansol, an advocate for the state, submits that the petitioner has deposited the amount, alleged overdrawn amount, without any demur, and accordingly the petitioner cannot claim for refund of the same. He seeks for dismissal of the writ petition. Baki questions the same. Rafiq Masi, question করুন. Upon hearing the learned advocates for respective parties, the only issue which calls for consideration is whether the direction issued by the respondent authorities to refund the alleged overdrawn of pay after retirement of the petitioner is sustainable or not. In order to examine Rafiq Masi code, it is found that the petitioner has retired from service on 31st March 2023. The amount has been deposited upon direction of the respondent authorities on 28th September 2023 and 17th October 2023, that is after his retirement. Bearing in mind the observation of the Honorable Supreme Court in Rafiq Masi Supra, such deposit, such refund, direction to deposit the overdrawn of pay is impermissible in law. Accordingly, baki directions are from the date of the interest away from the date of refund. The alleged overdrawn of pay amounting to line at further the alleged overdrawn of pay is for the period 1/1/2008 to 31st December 2019, which is more than 5 years. নিচে চলে আসুন, the alleged overdrawn of pay amounting to rupees 45,000 একটা লাইনই করুন, shall carry interest at the rate of 8% per annum from the date of respective refund till the actual disbursement of the amount. The respective কথাটা অ্যাড করুন, দুটো সেপারেট এতে আছে। Disposed of
With full option.
Eighteen.
18 মিলো time.
It is supposed to be listed next, but I have got the 29/6/2020.
Mr. Orijit Ghosh, learned advocate for the
Well, this is interest and gratuity and area pension মিলো।
interest and gratuity and area pension.
Yes, মিলো।
The interest and gratuity your lordship can.
Disposed of affidavit service filed on behalf of the petitioner is taken on record by the present
Here
petition. The petitioner seeks
গ্রাম
for
পঞ্চায়েত কর্মী মিলো।
disbursement of interest on delayed payment of gratuity and
Gratuity
area
and
pension from the date following the date of retirement till the date of actual payment. The petitioner contains that he was
26
appointed as a panchayat karmi and retired from service on 28th February 2025. As a panchayat karmi in Gadiar Puthi Gram Panchayat in district Jalpaiguri under Dhupguri block. The pension payment order was issued on 20th August 2025. The gratuity and arrear pension amount has been disbursed on 1st October 2025. However, no interest was paid, hence this writ petition. The rest same. 8%, 6 weeks from the date following the date of retirement till the date of actual payment. It and in the supplementary list.
Nineteen.
19 মিলো। The matters relating to revise area pension and gratuity miলো। Though the miলো, I have paid leave to the honorable court to first PPO miলো। Can you make it next circuit miলো? Because miলো first PPO is not available. I have annexed the second PPO, revised
Second.
PPO miলো।
Second PPO is under Mr. Devojit Kundul, under advocate for the state, advocate for the petitioner, seeks accommodation to produce the copy of the first PPO of the petitioner. Petitioner or husband of the petitioner?
Husband মিলো।
Husband.
Yes. এটা থাকবে next circuit.
Take this matter before the next available circuit bench.
Twenty.
20 minutes time for the petitioner. Here, my lord, the petitioner is claiming the gratuity and area pension, my lord. And petitioner is the Gram Panchayat for me. He retired from service on 28th February 2015. My lord.
The petitioner contains that you are for this case.
My lord.
Contains
Lord.
that
Claiming petitioner husband.
contains that he was appointed as
No, husband of the petitioner.
husband.
Yes,
Husband of the petitioner was appointed as a Gram Panchayat Karmi in Jateshwar
Jateshwar Gram Panchayat.
Gram Panchayat village and post Jateshwar police station Falakata district Jalpaiguri under Falakata block. The petitioner's husband retired from service on 28th February 2015.
Yes.
PPO pension payment is issued on 2nd March 2016. The gratuity and arrear pension amount was disbursed on 8th May 2016. However, no interest was paid, hence this writ petition. এখানে এই clause থাকবে delay clause. The husband of the petitioner expired on 16th April 2025. Hence this writ petition. From the day following the date of retirement till the date of actual payment.
Twenty-one.
20 minutes. I am for the petitioner. The petition is claiming my lord, interest on gratuity and arrear pension under revised SOPA 2019.
The RUPA,
Yes, SOPA 2019, which is effective on 14 February 2020.
revised
First PPO was issued. Petitioner himself. Date of retirement, my lord, 30th April 2018, and first PPO was issued, my lord, 10th July 2018. Thereafter, my lord, second PPO was issued on, my lord, 3rd February 2021.
টা কত?
947. 946 টা লাস্টে হবে লিস্টে, এটাই আছে 26 নম্বর হবে এটা। ও তো আমার দীপঙ্কর বোস না, দেখছি এই যে দেখুন
Affidavit of service filed on behalf of the petition is taken on record by the present writ petition. The petitioner seeks for disbursement of interest on delayed payment of revised gratuity and arrear pension amount under ROPA 2019
gratuity and arrear
at the rate of 18% per annum. The petitioner contains that he was
ও 7/4
appointed as a Panchayat Executive Assistant in Mathabhanga, 19 Bisa Gram
গ্রাম
Panchayat,
পঞ্চায়েত
the station Gushuk Danga, check করে নেবে, under Mathabhanga 2 block. The petitioner retired from service on superannuation on 30th April 2018. The first pension payment order was issued on 10th July 2018. The revised pension payment order under ROPA 2019 was issued on 3rd February 2021. Stop. The revised gratuity and arrear pension amount was disbursed to the petitioner on 1st March 2021. However, no interest was paid, hence this writ petition. Submission same 14th February 2020 till the date of actual payment. Panchayater. First January. তাই করে 1st January 2020. হ্যাঁ 1st January 2020.
15
ওরা আগে কোনো পঞ্চায়েতে ভুল হয়ে গেল নাকি? ঠিক আছে 1st February করে দাও, 1st January.
আচ্ছা ও এডুকেশনে হচ্ছে 14 ফেব্রুয়ারি এডুকেশন
Any day.
Right. 22 million. Time for the petitioner, Milord. Here, Milord. The wife of the petitioner is the employee of a Panchayat. No, single. বলছি দাঁড়াও।
ये
Milord, in this pair person, Milord. No. Well, single PPO here, Milord, wife of the employee, Milord, the husband claiming the interest on gratuity, Milord. Yes, Milord. The petition is the husband, Milord. And Milord, I am withdrawing the No, I am claiming only interest on gratuity, not area pension. No, not area pension. Here, Milord, I am withdrawing the portion of area pension, only gratuity. The petitioner claiming only gratuity because pension is not allowed. He is only dying harness, Milord. He is only servicing only 5 years. Only gratuity, Milord. No pension was disbursed because Milord, he served only 5 years. চলে যাও তুমি চলে যাও 19 যাও বিপটা আছে বিপটা নিয়ে থাকো মানে এই ডিপোজিশন গুলো আছে তো দিবা দিবি চাই Yes, 10 January.
23, the 23 need instruction.
23 Milord. Revised 2009. Roka 9.
Need 23 item number. No, need instruction. I have gone through the. Twenty-four.
24 Milord. I am for the petition. The petitioner paid for interest on gratuity and area pension both. Single. The petitioner is the lady attendance of the college, Milord.
Yes, sir.
7 December 2019. Milord. Milord, disbursed Milord, disbursed Milord 1st February 2021. Yes. Are issued Milord 3rd December 2019. পরে দেওয়া- পরে দেওয়া একটা। পরে দুইটা দেওয়া আছে 25 মিনিট রিভাইস মিনিট 2019 মিনিট ইন্টারেস্ট অন গ্র্যাচুইটি and area pension রিভাইস The first PPO was issued in 2016 and 7 PPO issued on 24th May 2021. It is good for template.
Twenty-six.
Ready. Interest on gratuity and area pension. Interest on gratuity and area pension. Single.
যদি মামলা না কম্পিটিশন মামলা নিয়ে যায় আমাদের ফাঁকা নেই বাড়ির খাওয়া বাড়ির যারা মোটা তাদের
8 October 2020.
My lord, this 27, I am for the petitioner. This is an income tax matter. My lord, this I'm challenging. The challenge is on twofold. My lord, one, as per Income Tax Act, an officer, the order should be passed by a faceless assessing officer, a faceless assessment. My lord, my challenge is on the basis there was a notification, there is a provision of 144B8, where under special circumstances, a principal commissioner from the approval of the CBDT or the Central Board of Direct Taxes can transfer back the assessment from faceless to jurisdictional officer. Here they invoked that. My lord, faceless is as per 151. There is a centralized processing center where they allocate randomly to people. Suppose, my lord, if I am sitting over here, my assessment might be done from somewhere in Raipur. I don't know the person, that is faceless. I don't know the person. That it has done, it completely done online. I submit paper online. If it is necessary, I can ask for a video conferencing, but even that is done in a very cloaked way, in a very secreted way or encrypted way, so that I don't know where the person is sitting. This is a faceless assessment scheme which came from 2021 in section 144B, my lord, the Income Tax Act. That I have that. My lord, subsequently what happened? Yes. Yes. I just have one copy. It's okay, my lord. I know the sections.
Lordship, I am the Revenue Authority, Your Lordship. My preliminary point in this, Your Lordship, there is a appealable order. Lordship.
My lord, this 144B1 talks about a faceless assessment for every assessment under section 143(3) or 147. My lord, I have marked it the 144B with a blue tag, my lord. That is the starting point. It talks about a assessment to be done in a faceless way for 143(3), 147 and different assessments. Well, up to 2-3 pages, the act has changed from 2021.
25 ওটা এখানে চলে আসছে।
ওটা আলাদা। Now, what happened in my lord, if you see, there is a provision in 144B subsection 8. My lord, that has been also tagged in with a blue tag. It says, extreme cases of urgency or exceptional circumstances, a principal commissioner or a chief commissioner for the faceless assessment can transfer back the file to jurisdictional officer with a prior approval from the CBDT or the board, as it is mentioned. Board is here is Central Board of Direct Taxes. Your Lordship, my lord, here the case is there was an reassessment under section 148A. So there are a lot of notices that were sent on portal. 148AB notices, subsequently 148AC reply comes, then 148AD order is passed, and 148 is a reassessment proceedings. They have done this through portal. Subsequent faceless portal. There is a portal, they have done it. Subsequently, they issued me a 143(3) notice, 143(2), that's the initiation of proceedings, asking for documents. Everything was done through portal. At the time of passing the order, they suddenly said, you know, it has been transferred back to me under section 144B8. There was no prior approval attached. There is no board approval or prior approval of the order of the principal CIT, which is compulsory, has to be given. Why it has been transferred? And the reason they have recorded, saying that you don't have a portal registration. If I don't have a portal registration, how were you sending me those notices? If your order is true, then your entire proceedings goes away because it was never served on me. Because, my lord, I will place the exact pages. They are saying that as by the virtue of a power of 144B8 of exceptional circumstances, as you are not registered in the portal or you don't have a registered email ID, we are getting it back to the jurisdictional officer. My lord, as you have read, the principal commissioner can, but there has to be an order and prior approval from the CBDT or the central board. The reason they have recorded is that you don't have a registration in portal. So the pre-assessment, to start a reassessment, there is a procedure under section 148A. The notices has to be sent. 148AB saying that I have found this averment. Why shouldn't I reassess your case? We reply in 148AC. They pass an order accepting or rejecting the order. My lord, this entire thing came from a Supreme Court judgment called GCAN Drive. My lord, I'm not going to go into that because it has come into a section. Subsequently, after 148AD, as per section 151, they have to take up approval from principal commissioner and issue me a reassessment notice. They have to start the reassessment. By note, they will start in 148 notice now as per the amended section. They can issue, the jurisdictional officer can issue after they have to transfer it out to the faceless assessment unit. Everything else will be done by faceless assessment officer. They did it. 143(2) was done by faceless. 142(1) notices were also sent by faceless. But subsequently, they transferred it back to the jurisdictional officer before passing the order, saying that exceptional circumstances has come before because you don't have a registered portal. So if I don't have a registered portal, no other proceedings then has to be followed because they were never served, because they were only served on the portal. So the order they have passed is statistically out of jurisdiction. They are self-contradicting. They are saying once they have done the entire proceedings of 148 and 148A through portal. While passing the order, they are saying that you don't have a portal. So I am being a jurisdictional officer. They assumed a jurisdiction under section 144B8, my lord, as you have read, and passed the order. My challenge is not on the order. My challenge is if you are right on transferring it out, then the reason you have given is self-contradicting to the fact that 148 notices were sent online. So the order, the 147 order, the assessment order, is ex facie illegal and out of jurisdiction. My lord, that is my only challenge.
Lordship, Lordship, I'm for the revenue authority. Lordship,
Madam, may I pray? Madam, may I pray? No, madam. Order is 46. Madam, may I place over there? Madam, despite being appealable, my challenge is not on the order. My challenge is how did you transfer in 148, 144 AB8? That is where my main challenge is. Sir, my lord, my contention is under what circumstances did you transfer it out? My lord, as you, my lord, lordship knows, despite an alternative remedy, there is a Godrej Nareli judgment where it says that if the order is on the face is out of jurisdiction, the writ may be maintainable. My lord, my challenge is on the jurisdiction of the assessing officer passing the order. I am saying that you cannot pass the order. Faceless assessment officer has to pass the order. My lord, this order, my lord, may I place? No, the order is in page 90 of the petition. Well, this is the assessment, final assessment order. Well, my challenge, this income tax officer Ward 14 cannot pass this order. This is out of jurisdiction. He does not have the jurisdiction to pass this order. Well, in page number 20, they have mentioned just a one line. There is no order, no board circular, nothing has been attached. Just a one line, my lord. The second paragraph from the top. My lord, may I please? Thereafter, the assessment proceedings 147, my lord, after everything they have transferred, was transferred to faceless assessment unit, which is as per law, under intimation to the assessee that assessment will be conducted as per proceedings of 144B8. My lord, I am not on that. Subsequently, the case has been transferred back to the jurisdictional assessing officer on 13/6/2024 with a remark, the pending assessment was item, a case where PAN is not registered or e-filing on the e-filing portal. If I am not registered, where did the notices go? Or if the registered email ID is not available. My lord, this is or. Either of the two has to be there. I have a registered portal. That's why I got those notices. In the system is transferred out on the faceless assessment scheme, my lord, 144B8, my lord, as I have placed before, of the act as jurisdictional officer for completion of, my lord, this is where my challenge is. You cannot, you don't have a reason, you don't have an approval also. Because the reason they have given, even considering they have an approval, the reason they have given is self-contradicting because then the entire proceedings they have started with 148A proceeding goes away because it was never served. Either this is true or this has been done, they have assumed jurisdiction without any prior approval from the board. Now, that is my case. My lord, I have all the notices. They have served me the notices on portal. Even they have said it before. The details they have sent. My lord, in the paragraph number 2, they have sent those notices. They have said that where the portal things have been sent. I have not complied, my lord. Acceptedly, I have not. Well, all the notices numbers they have sent it. They have written these are the notices I have sent. Well, attach the notices of 148A. Well, by the jurisdictional office. Well, previously. Yes, madam. It has to- They issued me the notice. The order was passed before passing the order. They assumed the jurisdiction by the jurisdictional officer. Madam, I have attached the 148 AG notice in page 12. My Malad, they don't have. Malad, they don't have. Malad, my learned senior is mentioning it is completely wrong. 251. Malad, Malad, the interim stating they filed the affidavit. Malad.
It did not previously said that we asked for the instructions, it was sent to the next circuit.
On that day you filed that?
Yes.
No, it is not here because that is not recorded in the order. Okay. By the present writ petition, the petitioner seeks for setting aside of the impugned order dated 19th March 2024 passed under section 148 capital A D of the Income Tax Act 1961, comma, the consequential notice issued under section 148, the reassessment proceedings undertaken by pursuant thereto, as well as the demand notice dated 12th March 2025 issued under section 156, being wholly without jurisdiction and contrary to law. Mr. Swanso, learned advocate for the petitioner, submits that the petitioner you attended the hearing under the faceless assessment. The petitioner was given notice for under section 144B for faceless assessment, and when the proceedings were under the faceless assessment, it was transferred to the assessing officer having jurisdiction without any prior approval of the board. The assessment order records that the PAN of the petitioner is not registered on the e-filing portal, or if registered, no email ID is available in the system. However, the assessment order has not recorded of any approval of the board in transferring the assessment of the petitioner to the assessing officer within its jurisdiction. Jurisdictional assessing officer. Jurisdictional assessing officer. Therefore, the action. Who has sent this? This has been reverted back to the assessing officer, jurisdictional assessing officer by. So the action of reverting back the case of the petitioner to the jurisdictional assessing officer is expressly bad in law. Mr. Ajay Kumar Singhania, learned advocate appearing for respondent's income tax department, submits that the assessment order passed by the jurisdictional assessing officer. This is under 148 capital A. Assessment order is under?
Under section 147, dated 144. First, your lordship, this is the reappointing assessment proceeding 148. Then assessment count.
Assessment order is passed under which section? 147. 147, read with section 144 of the Income Tax Act is an appealable order under section 251 of the Income Tax Act. And therefore, the writ petition is not maintainable. So far as the factual aspect is concerned, he seeks to file a affidavit in opposition. Let such affidavit in opposition be filed within a period of 1 week. A reply, if any, be filed within 1 week. It will expiry. Liberty is granted to the parties to let it come up after the exchange of affidavits. You press for that. No. Not now. Not now. Next. Yeah. Liberty is granted to the parties to mention after expiry of the aforementioned.
The 28.
My lord, I am being led by Mr. Kaur.
Appearing for the petitioner, my lord.
Sir is appearing for?
My lord, I am appearing on behalf of the petition. I am being led by Mr. Kaur.
Before the petitioner starts lordship, may I submit one thing, lordship? In this case, the answer is responding in the Mal municipality lordship, not the state lordship.
So,
My lord, we have,
My lord, on
this
the
is the
previous
affidavit of
occasion-
service.
My lord,
Give
the
the-
previous occasion, my lord,
Publish
learned
his
advocate-
instruction with you. Pritham Das.
Mr. Pritam Das, my lord, we have also intimated
sir.
them. My lord,
Oh. Intimated. What is the instruction given? Mr. You have given notice to the learned advocates?
my lord, the matter
On-
appeared, my lord, on 11th June. They have sought for time, my lord, the advocate for the learned advocate for the municipality. My lord, on 13th February 2026, my lord, the Honorable Coordinated Bench directed the learned advocate for the municipality to take instruction whether there was any due outstanding dues or not.
What is this due amount about?
My lord, it's a contract amount, my lord, tender amount. Petitioner
You have,
completed the work.
you have completed the work.
Yes, my lord.
Where is the completion certificate?
But they have not issued it, my lord, but they have issued 2 checks after completion, my lord.
Where is that?
My
Copy?
lord, page 21, my lord.
No, page 20 is the work order.
21, my lord, 21.
2021. So thereafter, you have deposited the check.
Yes, my lord, it has been credited to my account, but my lord, 9,81,790 rupees is due till date, my lord.
What was the total amount outstanding?
Total amount was, my
It's-
lord, at page 20, my lord. My lord can find tender amount 36,06,927, my lord. At page 20, my lord.
Okay.
Out of that, my lord, 22,57,618 rupees was credited by 2 checks, my lord.
Okay. একটু পাশে করো 10 মিনিট পরে একটু কল করো।
My lord, one indulgence, my lord. Item 84 also, my lord, similar matter, but it has been listed wrongly as GST matter, my lord. Item 84, same advocates, my lord.
84.
My lord.
It is also outstanding.
Yes, my lord. Similar matter, same petitioner, my lord. And same advocates, my lord.
ঠিক আছে 10 after 10 minutes. আর রিসেসের পরে কি আছে? দেখি ওটা কি আছে? ওটার পরে এটা নেব। Can you intimate the learned advocate, Mr. Das?
My lord.
After the recess, there is one matter at 2 p.m. Thereafter,
My
I'll
lord.
take it.
My lord.
After 2.
My lord, both the matters, my lord.
Both matters.
Okay.
These are all dues.
Yes, my lord. Item 28 and 84, my lord. Other 2 matters are there,
Okay,
my lord, but it
28.
has not been listed, my lord. My lord.
Okay. After the recess, I'll take it up. There is one fixed matter at 2 p.m. Thereafter, I'll take it.
Grateful, my lord. Grateful.
Next order.
Last petition.
Petitioner take.
Pending bill. Because last petition also
The bill for verification. What happened? You have produced the bill.
I have appeared before the concerned BDO and submitted my representation again that on the basis of those bills which I have submitted, I have already got some amount from them. Apart from that, I also got 2 lakhs from them from my pending bill. Nowadays, not for the last letter of self-inscription, there was 19 lakhs was due. Nowadays, not that is 17 lakhs will be due.
17 lakhs.
17 lakhs 45,694.
What is your report?
Now there. Now
What is the report?
In the very consequent data to the petitioners to provide all the bills and challans voucher. Till now, the petitioner is eligible to provide the challan copy as well.
we have already submitted before the concerned authority. On the basis of those documents, they have issued in total 8 lakhs to me. 8 lakhs 90,380 rupees to me. Now they are, when I am demanding for your lordship that I am entitled to get more 17 lakhs, they are again asked me to file the charge. It is not a case. Not a single amount has been received by me from them.
We are not disputing lordship, but we need some challan.
That may be misplaced from your office. Why I will be responsible for that? On the basis of those.
What is your report? Give that. Give a copy of the report.
We got the undersigned right to inform that the petitioner, Mr. Kandesha Roy, submit valid challans for receipt of supplies material. It is difficult to determine how much money is payable to the petitioner against the quantity of the material supplied. but the petitioner is unable to produce the same, therefore it is difficult for the undersigned to determine the amount to be paid to the petitioner lordship.
My humble submission to your lordship, already
how-
they have disbursed a sum of rupees 8,19,380 on the basis of those bills.
This you have stated.
What?
You have stated in the writ petition.
This is the page number 18.
5 lakh 7.
Presentation before the video. First, second paragraph, my lord. Yeah, I need to read out.
Second.
Page number 18.
Page 2, 2026.
No, I agree. I have received the list. I agree. Now, my lord, can you see the page number 18? Total bill was 25 lakhs 6,554. Out of which we have received at the first instance 5 lakhs 70,000. Nowadays we have received 8 lakhs 19,380 in total. Out of the 16,554.
This was necessary paperwork.
If we have not deposited those documents to them, how they disburse those amounts?
This has been given to the office of the block development officer. Oh. Then you disburse the balance amount. Disburse the balance amount, find out, verify. Verify the claim of the petitioner.
Whatever the fund has done for this purpose, lordship, fund has already disbursed lordship among the those who are providing.
No, if the fund is not there, then you reallocate the fund, get it from the government and make payment.
Already we have filed challan.
He says that challans have been filed. No, only saying that, see, only saying that your office does not have the challan does not absolve you from producing those challans. How?
No.
How?
Finding anything here, they don't have. We only need the Xerox copy, photocopy of the challan.
My humble submission to your lordship, if I cannot satisfy them, how they disburse 8 lakhs 19,000 to me?
Is that very time
They had the documents. Now, if they misplace the documents,
no, that is
now
not
they are
this-
demanding us.
Whatever
Submit.
amount was paid.
Please find the requirement of fund.
According to the receipt of the challan lordship.
No.
Now they are asking for the further fund lordship. They has to submit lordship some document that at least relying upon that we will ask for the further fund lordship.
One thing may I permit to say, madam. Kindly see the page
Madam,
number
you
18.
try to resolve the issue, otherwise I have to pass an order.
Kindly one other gentleman. I am just requesting my learned.
Can you give us at least 18 days time, because this matter was spent, and today we are on 18, only 18 days to determine.
No, how do the, how he says that it is difficult to find out documents at the time of receiving the articles, you didn't have any difficulty. Now at the time of payment, you say that you have difficulty in finding out the office records.
That is the problem.
It is a duty of the petitioner if the department is.
Where is Mr. Bhattacharya?
They should have-
Where is Mr. Bhattacharya?
I have.
Give us the 15 days time.
It's not a question of time. How could the block developer write this, that it is difficult to determine how much money is payable? It is determinable that the amount of articles which has been used, that is determinable. Yes.
Kindly not because this is big, lordship knows kindly. Read that one. Whatever, why not we'll get some more instructions, my lord. What I have understood, my lord, the provisional payment has been made. Some payments are required, they're asking for balance payment. There's some kind of dispute, or maybe my lord, the challans are not available at the end of the office. We'll take instruction, my lord, if required. The petitioner can, my lord, submit office copies of the bills, or at the end of the day, it has to be reconciled. and they can get the money. Kindly, my lord,
Chalo. हाँ सुन देखिए.
kindly not, my lord, my humble request, my lord, kindly not pay attention to the first page. My lord.
Why?
Okay, Mr.
That, my lord, is,
My lord, that takes special notice about.
Mr.
that, my lord, that is a.
Joydeep Kanto Bhomik, learned advocate appearing for the petitioner, submits that his client is not having the copy of the concerned bill and therefore he could not produce the bills for verification. Mr. Kunaljit Bhattacharya, Ms. Supriya Singh, learned advocate for the state respondents, submits that the bills are being searched and would be the bill of the concerned bill of the petitioner will be reconciled. She seeks some accommodation to take further instruction. Release this matter before the next available circuit bench.
My lord, one is done this, may I say? That is matter may be. Yes, nothing may be concluded within a specified period. I'm disappointed.
Let it come up before the next available circuit bench. If you have the copy, kindly place it. Chalo.
I furnished it. She has ordered to pass the approach the order. It has been done, but unfortunately.
To be mentioned tomorrow. What is there? What is the mistake? What is the mistake?
Virtual mode, one thing I have personally appeared before your lordship. And there are.
No, Mr. Sarkar, it is of the order dated 12 June. You were virtually present on that day. You were on 12. No.
Virtual.
I remember on the first day you were present physically. On the date the matter was 12 June.
This is the last.
Virtual. The order is passed on 12 June. You go to the 10th June order. 10th June order, your record, there is no virtual appearance. On 12th June, there is appearance virtual. It has been rightly. That I have noted.
I don't think so. Go serially, we have a fixed matter. Let him move.
Mentioned the matter today morning, but we thought it would be taken in the course, but now there's a but our construction is stopped.
My lord, I am the petitioner, my lord, appearing person. My lord, the issue in crux is that, my lord, I'm the petitioner, my lord, acting as a partner of the partnership firm, one of the partner. Now, my lord, the firm has applied for registration before the respondent authority, which is the Register of Firms, Societies and Non-Trading Corporation.
Your
And-
application?
My lord, I'm coming to that. My lord, my application starts from page number 53, annexure P2.
Okay. Yes.
Yes, my lord will find in the additional info, 1, 2, 3, fourth line is the trade license date.
Yes.
My lord, so it has been left blank because there was no trade license. My lord, this application was filed and ultimately, my lord, lordship will kindly come to page 57. Lord, this is the statement required for registration of the firm. Lord, as per page 57, my lord.
Yes.
My lord, as per section 58 of the Act, my lord, this is the document, my lord, which has to be filed with the registrar concerned, my lord, for registration of a partnership firm. So this is complete in all respect, my lord. It consists the name of the firm, my lord, the duration of the firm, the principal place of business with full address, and name of any other persons where the firm carries business with full address. And the next page is, my lord, the details of the partners. So the requirement of section 58, my lord, stands complied with respect to this statement of form. Now, my lord, since I did not file the trade license, my lord, there was a mandatory field, my lord, which cannot be left blank in the portal. So, my lord, I had, my lord, written a representation and I have uploaded that in place of trade license, my lord, that is in page number 61. So, my lord, this representation in detail, my lord, carries out, my lord, why the trade license is not applicable on lawyers or a firm of lawyers. And at the same time, the section 58 also does not require a trade license to be filed with the registrar during registration or for the purpose of registration. So this detailed representation, my lord, was not adhered to. Nothing, my lord, with respect to this representation, my lord, is there. Next, page 64 is the, my lord, is their refusal, their observation. Now, my lord, in addition to the requirement of a trade license, my lord, there were some other anomalies also. The photos were not clear. So all those deficiencies were rectified except the trade license, and it was refiled with the registrar again. My lord, page 65 onwards is the second application.
Page
The application,
64, where is the mention of trade license?
my lord.
There may be return.
Effective date of.
Yes, yes.
Yes, effect
Yes.
date / trade license date.
Okay.
So, my lord, except this, all other deficiencies were cured, my lord, and the application was refiled. Page 65 is my second application, my lord, which was filed on 19th of April 2026. My lord, again, same thing, my lord, I had, in addition to a second representation, my lord, in the remarks section also, my lord, I have made few observations that the law firms, my lord, they do not require a trade license. In page 67, lordship will find in the
Second
form.
time also it has been returned.
Yes. Second time also returned, my lord, solely due to want of trade license. And in page 68, lordship will find initial trade license, correct trade license. These are the mandatory attachments to be filed with the form, my lord, for submitting the form. So unless, my lord, I fill something there, I upload something there, the form will not be accepted. So, my lord, I have written a representation, I have uploaded it, and it was submitted. And finally, my lord, the application was returned again due to want of trade license. Lordship will find that in page 73, the second refusal.
Yes. This is
the first in the comment section, upload initial and current trade license. Now, my lord, this is the facts in nutshell. Now, my lord, my submission is based on, but I have two limbs basically. First is that when a law firm or a body of lawyers, being a professional person or a body of professionals, they are being governed by a specific statute and a specific statutory body. In addition to the requirements of that statutory body, there cannot be additional restrictions upon the lawyers. Second limb of submission is Section 58 of the Indian Partnership Act specifies what are the conditions required to be fulfilled for getting a partnership firm registered. Once those conditions are fulfilled, the registrar is duty bound under Section 59 to register the firm. Page 58, page 53, section 58. But the registration of a firm may be effected at any time by sending by post or delivering to the registrar of the area in which any place of business of the firm is situated or proposed to be situated, a statement in the prescribed form and accompanied by prescribed fee stating the firm name, the place or principal place of business of the firm, the names of any other places where the firm carries on business, the date when each partner joined the firm, the names in full and permanent addresses of the partners, and the duration of the firm. The statement shall be signed by all the partners or by their agents, specially authorized in this behalf. Each person signing the statement shall also verify it in the manner prescribed. A firm name shall not contain any of the following words, namely Crown, Emperor, Empress, Empire, Imperial, King, Queen, Royal, or words expressing or implying the sanction, approval, or patronage of government, except when the state government signifies its consent to the use of such word as part of the firm name by order in writing. Now, section 59 deals with registration. It says when the registrar is satisfied that the provisions of section 58 have been duly complied with, he shall record an entry of the statement in a register called the Register of Firms and shall file the statement. So, my lord, this is the law. But section 58 is very clear, my lord, that what are the documents or what are the details, particulars which has to be furnished to the register for getting the firm registered. Nowhere, my lord, there is any requirement of any trade license. Now, my lord, I come to my first limb of submission, my lord, why it is not applicable on lawyers. My lord, I rely on a judgment of the Honorable Supreme Court. This is a 1984 judgment. Kindly come to para 8. It's in page number 3, my lord, para 8.
Yes.
A lawyer's office or the office of a firm of lawyers cannot obviously fall under clauses 3 and 4 above, nor has the government issued any notification as contemplated by section 2(4). The question thus narrows itself into whether a lawyer's office falls under either of the first two clauses. The expression establishment is defined by section 2(8) to mean a shop or commercial establishment. Since by the definition contained in the first clause of section 2(4), a commercial establishment means an establishment, a place of work cannot be regarded as a commercial establishment unless the activity is conducted in a shop or in a commercial establishment, which is really tautological. The definition of shop, which is contained in section 215, shows that in order that an establishment can be regarded as a shop, it is necessary that some trade or business must be carried on there or some service must be rendered to customers. The expression shop also includes offices, warehouses, storerooms, or godowns which are used in connection with the trade or business. It does not require any strong argument to justify the conclusion that the office of a lawyer or of a firm of lawyers is not a shop within the meaning of section 215. Whatever may be the popular conception or misconception regarding the role of today's lawyers and the alleged narrowing of the gap between a profession on one hand and a trade or business on the other, it is tried that traditionally lawyers do not carry on a trade or business, nor do they render services to customers. The context as well as the phraseology of the definition in section 215 is inapposite in the case of a lawyer's office or the office of a firm of lawyers. Learned counsel for the appellant argues that the lawyer's office is a commercial establishment because persons who are employed in that office are mainly engaged in office work. This argument overlooks that under the second clause of the definition in section 2.4, commercial establishment means an establishment or administrative service in which the persons employed are mainly engaged in office work. Partly, we go back to the same question as to whether a lawyer's office is an establishment within the meaning of the Act. The other aspect which this argument fails to take note of is that a lawyer's office is not an administrative service. It seems to us doing violence to the language of the second clause of section 2.4 to hold that a lawyer's office is an administrative service. This argument has therefore to be rejected. The proposition is well established that words which occur in the same context must take their color from each other. It is unrealistic to dissect the definition clause in section 2.4 and to catch a word here or there in order to bring a lawyer's office within the four corners of the definition of commercial establishment. The various clauses of that definition would show that establishments fall apart from professional offices were within the contemplation of the legislature. For these reasons, we are of the opinion that the office of a lawyer or a firm of lawyers is not a commercial establishment within the meaning of the Act. So, my lord, this is the ratio, my lord, laid down by the Honorable Supreme Court back in the year 1984. And my lord, subsequently, even the Supreme Courts and many other high courts have relied on this V. Shashi Saran judgment. My lord, I rely on the judgment of our high court, my lord, passed by Honorable Justice Mukherjee, a very recent one, my lord, though it is in connection with chartered accountants, but the analogy, my lord, the Honorable Court says the analogy is applicable to lawyers as well as chartered accountants being professionals. Lord, kindly come to para 9. Lord, V. Shashidharan was earlier discussed, and then, my lord, this is the observation of the Honorable Court. It is on the basis of these definitions that it is to be decided whether the office of a chartered accountant or a firm of chartered accountants is a commercial establishment within the meaning of the Act. The expression establishment is defined by section 2.8 to mean a shop or a commercial establishment. Since by the definition contained in the first clause of section 2.4, a commercial establishment means an establishment, a place of work cannot be regarded as a commercial establishment unless the activity is conducted in a shop or in commercial establishment, which is really tautological. The definition of a shop, which is contained in section 215, shows that in order that an establishment can be regarded as a shop, it is necessary that some trade or business must be carried on there or some service must be rendered to the customers. The expression shop also includes offices, warehouses, storerooms, or godowns which are used in connection with the trade or business. It does not require any strong argument to justify the conclusion that the office of a chartered accountant's office or the office of a firm of chartered accountants is not a shop within the meaning of section 215. Whatever may be the popular conception or misconception regarding the role of today's lawyers, an alleged narrowing of the gap between the profession on one hand and a trade or business on the other, it is tried that traditionally lawyers do not carry on a trade or business, nor do they render services to the customers. The context as well as the phraseology of the definition in section 215 is inapposite in the case of chartered accountant's office or the office of a firm of chartered accountants. A professional activity must be an activity carried on by an individual by his personal skill and intelligence. There is a fundamental distinction, therefore, between a professional activity and an activity of a commercial character. Considering a similar question in the background of section 2.4 of the Bombay Shops and Establishments Act 1948, it was held by the said High Court in Devendra M. Surti was the state of Gujarat, reported in so and so, that a doctor's establishment is not covered by an expression commercial establishment. Upon considering the arguments and materials of both the parties, the court holds that a chartered accountant or a chartered accountant firm cannot be termed as a trader or businessman, and professional firm cannot be equated to business or trade as within the ambit of shop as contemplated under the ESI Act or the State Act as held in numerous judgments. So, my lord, these judgments were considered, my lord. One of the judgment is V. Shashidharan also. So, my lord, the Honorable Court has clearly said, my lord, that when it is a professional body, particularly, my lord, the lawyers or the chartered accountants who are being dealt with a separate statute, my lord, they cannot be held as doing trade or business, and all these additional restrictions cannot be imposed upon these professionals. Whether it is an individual professional or a firm of professionals, my lord, that doesn't change the nature and character of the profession. My lord, this is all, my lord. There are many, but I am not troubling your lordship with so many judgments. My lord, my second limb of argument is section 58. My lord, with respect to section 58, our Honorable High Court or Division Bench of the Honorable High Court has clearly laid down a ratio, my lord, back in the year 2010, that when the conditions of section 58 have been fulfilled by the applicant seeking registration, the registrar is duty bound to give the registration. The registrar cannot come with any additional conditions, restrictions to grant registration. But I rely on the judgment of Registrar of Firms, Societies and Non-Trading Corporation versus Torun Manna. Milord, here also one person, Milord, who was the partner, one of the partner, Milord, had filed a writ application, said the writ application was allowed in favor of the applicant. The Registrar of Firms challenged it before the division bench, Milord, and this is the observation of the division. Milord, para 11, Lordship. Yes. After hearing the learned counsel for the parties and after going through the aforesaid provisions of the Act, we find that the partnership is the relation between persons created by contract, whereby the parties to such contract have agreed to share the profits of a business with further condition that the proposed business must be carried on by all or any of them acting for all. Therefore, the first condition of existence of a partnership is that there must be an agreement by the partners to share the profits of a business. The other condition is that such business must be agreed to be carried on by all or any of them acting for all. In other words, there must be existence of agency among the partners of the proposed business as specially recognized in section 18 of the Act. Once an agreement to run a partnership business is entered into and the partners have formally executed the deed incorporating the terms thereof, the next step is of registration of the firm, which is of course optional and not compulsory, but in the absence of registration, it creates a lot of impediments in the smooth running of the proposed business as pointed out in section 69 of the Act. Section 59 of the Act discloses the mode of making application for registration, and section 59 casts a duty upon the registrar to register a partnership after being satisfied that the requirements of section 58 are complied with by the applicants. A plain reading of section 58 makes it clear that even if the actual transaction of the proposed business have not yet started, the partners of the proposed firm can make application for registration of the partnership before the register of an area where the partners have agreed to start a proposed business. If a partnership is not registered, although in a given case, the running of the proposed business may not be illegal, yet as pointed out by section 69 of the Act, neither any suit to enforce any right arising out of a contract or conferred under the Act at the instance of a partner against the firm or other partner shall lie, nor shall such unregistered partnership be entitled to file a suit against a third party with whom it has entered into any business contract. Thus, it is absurd to suggest that a firm should start its business consciously being aware that if in the process of such business it is defrauded by a third party, it will not be able to maintain a suit for appropriate relief, and only after taking such risk it can apply for registration. It is now settled law that the bar created by section 69, even cured by subsequent registration, cannot be, yes. And finally, my lord, para 16, the last paragraph, my lord. As pointed out above, although a partnership firm can come into existence and function without being registered at its own risk and at the risk of a third party who deals with it, it is not the law that in order to have registration of the firm, the partners must be first exposed to the risk of loss by dealing with the third party without having any registration, and then can only acquire the right to apply for registration. Moreover, there are various types of business which cannot even be undertaken without first taking license from the appropriate authority, and thus, if we accept the contention of the appellants, a partnership firm, even after its formation by execution of a deed, will not be entitled to apply for license on the ground that there is no partnership in the eye of law as the business has not commenced. We should bear in mind that partnership is the relation among partners created by agreement, and the object of section 58 of the act is to register such agreement by keeping note of the particulars of the agreement arrived at by the parties for the benefit of the partners as well as third parties who propose to deal with such firm. In this case, the Register of Firms raised an objection that the firm has not yet commenced business, so it is not entitled to registration. So the register virtually tried to plant an additional restriction that you have to commence business and thereafter you can seek for registration. So the court categorically said, you cannot. Section 58 is a provision which contains how the registration has to be done and what as a register you have to do. You have to only collate the documents, keep it in the statement in the register, and you have to maintain the records. That is the only function of the register, nothing more, nothing less. Register cannot impose additional conditions which frustrate even the statute. The section 58 is the statute. The legislature in its wisdom has laid down section 58. The authority under the said act is creating additional restrictions which is beyond the even the statutory power, statutory provision. So under such circumstances, this application may kindly be allowed with a direction to the register, that the application, that the firm be registered first. Second, I have prayed for a declaration, that the being a professional firm, being a law firm governed by the Bar Council of India Act, let there be a declaration, that this is not under subject to any trade license, anything, with regard to that. Rule making part of
Short points here. First and foremost, my instructions are that there is a procedure, my lord, which has been in place for registration of firms. Set of documents are required to be given. Now, the question of the two judgments regarding, my lord, whether the profession of a lawyer is a commercial activity or not, it is a settled law, it is not. But having said that, my lord, certain conditions under certain laws can be imposed. Say, for example, my lord, I'm not very sure, but I think I've heard it, my lord, that in case of registration under the GST, my lord, law firms having a particular turnover beyond that are required to be registered under GST. No, beyond a certain limit there are. I may be wrong, my lord. GST about that, my lord, I may be wrong, but I possibly, my lord. So even, my lord, say for example, I am asking a law firm to produce a trade license for registration does not make the profession a commercial profession. It is a requirement for the ease of registering the firm. Now, the register of firms, my lord, yes, section 58 does not specify a trade license to be produced. It says the name, principal place of business of the firm, and etc. etc. Now, one of the requirement of trade license is to ascertain the principal place of doing of business of a partnership firm. Second, my lord, this there is, I just received.
But the partnership firm has the address in the place of business is there.
Now, this, my lord, my learned friend, my lord, has been kind enough to accept. My lord, this, my lord, is the procedure which I have downloaded. I have been sent by my client, my lord. This is there in the website. If your lordship kindly sees, my lord, the comprehensive list of documents for registration of a partnership firm. There, my lord, the second and third is in relation to a partner trade license, my lord.
It also says if any. So that is not.
Point. There is this Bengal partnership rules.
Yes.
I've not been able to get a copy of it. I have okay, well, my rule 6 says that on receipt of every statement, intimation, notice, or any other document required by the Act is the Partnership Act. To be filed or registered in the office, the registrar shall examine it, and if it is found to be defective or incomplete in any of the particulars required to be given therein, or not verified in the manner prescribed by these rules, or in any way not in accordance with the provisions of the Act or these rules, he shall return it to the person who applied it for filing or recording, or to the firm concerned, and until proper rectification or completion is made, he shall not register or file the document in question. So, there is a discretion power given to the registrar matter for this satisfaction. I hand over this. So one of the heading of submission by the my lord that what I have understood, my lord, that demanding a trade license from my lord make the work of the law firm as a commercial activity or a simple law. It cannot work. The work of lawyer do not come within that definition. And second, my lord, the register of firm, my lord, he is bound by certain procedures, my lord. There it says one of the requirement of the document is this. So one more thing, my lord, yes, no. Since the law firm has applied for distinct PAN number, PAN number, in that case, my lord, the trade license.
He has a pen.
Yes, he has a separate PAN. Now, these are my first. Because he has raised 2 points. But first is.
They said that for the ease of registration, Milord, this has been done. Milord, I don't know how this is, Milord, making my registration process easy, because this is restricting me, Milord, from getting registration. First. Second, Milord, he has referred to a rule. Milord, I'll come to that later, but there are other points, Milord, he has raised. First is PAN. Milord, PAN is PAN refers to permanent account number. Milord, this is issued by the Income Tax Department to all entities who are paying or who intend to pay tax to the government. Milord, I as an individual, I do have a PAN card. Milord, Mr. Bhattacharya must be having a PAN card. Milord, everybody, Milord, who is paying taxes, they do possess a PAN card. Now, Milord, this firm, when I am earning as a lawyer, I am paying tax on my personal income. In the similar way, Milord, the firm, when it is because we are not getting any direct, when the firm is accepting briefs, the payment is coming to the firm. So out of the personal income of the firm will be paying income tax. So, Milord, how come having a PAN card makes it, Milord, necessary for the municipal authorities or other authorities to issue a trade license? There is no connection directly between the PAN or trade license. So this is absolutely, Milord, this is fallacious, because if that would have been true, even I as an individual lawyer, Milord, I need to have a trade license to function. So this argument, I don't know, Milord, how come this is coming from the register of firms? Milord, next he says the work of lawyers, even after grant of trade license, shall not make it commercial. The nature will not change. Milord, if the nature will not change, why they are insisting for a trade license? The name itself says trade license. It is required for somebody or some entity which is into trade and business.
You are having a PAN.
I am having a PAN.
That
Yes.
partnership firm has a
Yes, it has a PAN.
This has been submitted.
Yes, submitted. Now, Milord, Bengal partnership rules. My learned friend has referred to a rule. Now, Milord, the rule-making power under the Partnership Act, Milord, is governed by Section 71. Lordship, this is a very settled law that
Section 71 of
Section 71.
of the partnership.
A partnership rule, yes. Section 71 is the Milord, section which grants power to the authority to make rules under the Act. Milord, before I read the section, Milord, this is a settled law that the rule-making power gives the authorities concerned to make rules under the Act to supplement the provisions of the Act. But the rule-making power, my lord, cannot traverse beyond the periphery of the statute. My lord, the statute is the final boundary. The rule-making power, the rules coming under the statute, my lord, has to be under the parent statute. It cannot override the statute itself. Now, let us see section 71. The state government may by notification in the official gazette make rules prescribing the fees which shall accompany documents sent to the Register of Firms, or which shall be payable for inspection of documents in the custody of the Register of Firms, or for copies from the Register of Firms, provided that such fees shall not exceed the maximum fees specified in Schedule 1. The state government may also make rules prescribing the form of statement submitted under Section 58 and of the verification thereof, requiring statements, intimations, and notices under Section 60, 61, 62, and 63 to be prescribed in the form, and prescribing the form thereof, prescribing the form of the Register of Firms and the mode in which entries relating to the forms are to be made therein, and the mode in which such entries are to be amended or notes made therein, regulating the procedure of the registrar when dispute arises, regulating the filing of documents received by the registrar, prescribing conditions for the inspection of original documents, regulating the grant of copies, regulating the elimination of registers and documents, providing for maintenance and form of an index to the Register of Firms, and generally to carry out the purpose of this chapter. All rules made under this section shall be subject to the condition of previous publication. Every rule made by the state government under this section shall be laid as soon as it is made before the state legislature. Very important, subsection 4. As soon as it is made before the state legislature. So whenever rules, from the four corners of section 71, nowhere it has been, the rule making power has been given to the authority to make rules to call for additional documents in addition to section 58. Nowhere. And whatever rule you make, this is rule making power. Whatever rule you make, that has to be laid before the state legislature. Now, what my learned friend has relied on. Now, my lord, what this procedure, my lord, perhaps this is the copy, my lord, my lord, my lord, procedure for registration of partnership firms. Lordship has seen that what Mr. Bhattacharya has submitted.
Yes.
My lord, so far my understanding is concerned, this is not a rule. This is a simple guideline, my lord. This is displayed in the website of the firms for every individual, every citizen's, my lord. Even I have accessed this, that what is the procedure, how the.
It's a rule, my lord. I said this is a guideline. I said this has been given to the registrar to complete the registration.
Yes. So, my lord, there is no admitted rule which governs, my lord, how additionally, even if you call for anything, that the state government has made a rule, and under this rule, the register is functioning. No such rule is existing. This is a procedure for registration of partnership firms. This document says that comprehensive list of documents for registration. Here they say the current trade license and branch office, this has to be submitted. But where from they are deriving this power, my lord, I don't know. Nowhere in the statute, my lord, gives them such a power, my lord, where they can call for additional documents. So this is my humble submission, my lord. Hopefully I have covered all the points, my lord, raised by my learned friend. So, my lord, that is all. Yes. Oh, my lord, sorry. My lord, one judgment, my lord, I'll be relying on the rule making power. Sorry, I missed it out. Very short one, my lord, 2 paragraphs. না তুমি রুল মেকিং পাওয়ারের উপর প্যারা 20 not প্যারা 21 to 32 এত কিছু পড়বো no, this is a long one, my lord. I will not waste your lordship's time. Para 21 to 32, my lord, I'll just say the gist. My lord, rule making power, this is the ratio from this judgment coming out is rule making power does not exceed the periphery of the parent statute. If it does, my lord, the rule becomes ultra virus to the statute, and that has to be struck down, my lord. It has to pass the test of constitutionality. So, my lord, that has to be followed, my lord, while rules are being framed under a particular statute. That is the ratio, my lord.
By the present writ petition, the petitioner seeks direction upon the respondent authorities, particularly the respondent number registrar, office of registrar of firms, societies and non-trading corporation to accept, process and register the application for registration. This application number is subsequent one. He has made two applications. The prayer portion has an application number of same. Oh. Number APP 022334 submitted in respect of Messrs. Pinava Legal, an unregistered partnership firm of advocates, without insisting upon a trade license. And further declaration that insistence upon production of a trade license as a precondition for registration of a partnership firm consisting exclusively of advocates carrying on the profession of law is arbitrary and unconstitutional and ultra vires the Indian Partnership Act 1932 and contrary to the Advocates Act 1961 and Bar Council of India rules. The petitioner contends that he is an advocate by profession and in his individual capacity as a partner of Messrs. Pinava Legal, an unregistered partnership firm of advocates, has challenged the repeated refusal of the respondent authorities to register the said firm under the Indian Partnership Act 1932 on the ground of non-production of trade license. Dr. Arjun Chaudhary, petitioner in person, one of the partners of Messrs. Pinava Legal,
Sorry, excuse me.
yes, Legal, submits that the unregistered partnership firm of advocates applied for getting registration of the said partnership firm before the registering authority. The preliminary objections which were raised by the registering authority has already been complied with, save and except the insistence of a trade license to be submitted for having the registration of the partnership firm. As per Section 58 of the Partnership Act, there is no requirement of submission of trade license. Once the requirement under Section 58 of the Act of 1932 is complied with, the registrar concerned is bound under Section 59 to register the partnership firm. Therefore, the refusal to register the partnership firm is arbitrary and should not be on the ground of non-production of trade license should not be insisted upon. relying on the decision of Honorable Supreme Court in V. Sasidharan versus Messrs. Peter and Karunakar and others, he submits that the lawyer's office or a firm of lawyers is not a commercial establishment within the meaning of the Commercial Establishment Act. 2(4), sorry, within the meaning of 2(4) of Commercial Establishment Act. Reliance is also placed on the decision of a coordinate bench of this court in Santosh Chaudhary and Associates versus Employee State Insurance Corporation and another. Which paragraph of this judgment you are relying? 9. Right. In view of such submissions, he prays for necessary direction upon the registering authority to register the partnership firm under the Indian Partnership Act 1932 and also not to insist upon production of the trade license. Mr. Kunalji Bhattacharjee, learned additional government pleader, representing the state respondents, আরেকটা judgment আছে আরেকটি দিল যে এটা ডিভিশন বেঞ্চের জাজমেন্ট আছে এটা হচ্ছে Registrars of Farms, Society and Non-Trading Corporations, West Bengal and another versus Torun Manna and others, reported in AIR 2010, Calcutta 79. Kunalji Bhattacharya submits that as per the guidelines for registration of partnership firm, there are list of documents which is to be produced by the concerned firm for registration of the partnership deed, which also includes initial and current trade license. That rule, you place that rule? He has taken the tab.
The guidelines.
No, that rule he was referring to. Bengal partnership rules. Okay, you give that. Much. Having heard the para, Having heard the learned submission है, stated submission है बोलो. Referring to Bengal Partnership Rules 1933, Partnership Rules 1933, he submits that the registrar is to act in accordance with the rules as framed thereunder prior to and on being satisfied shall register the documents. It will give a copy of this. Huh? Regard the learned advocates for respective parties, the only issue which falls for consideration is whether the respondent number 2 was justified in refusing to register the partnership firm, namely Messrs. Pinava Legal, on the ground of non-production of trade license. In order to examine such issue, it would be profitable to reproduce the provisions of Section 58 of the Indian Partnership Act 1932 as hereunder. The aforesaid provision clearly lays down the procedure which is to be adopted, and the application for registration has to be submitted with the statement in the prescribed form giving the particulars as provided therein, namely from clause A to F. There is no quarrel that the firm for getting registration has complied with Section 58. Section 58 of the Act of 1932 does not provide for production of any trade license. Section 59 of the Act of 1932 provides for registration, provides that when the register is satisfied that provisions of Section 58 has been duly complied with, he shall record an entry of statement in a register called the Register of Firms and shall file the statement. Since Section 58 has been duly complied with by the partnership firm, the registrar is under statutory obligation to cause registration of the firm. Para. It is settled principles of law as argued by Mr. Dr. Chaudhary, the petitioner in person, relying on V. Sasidharan Supra and Shantosh Chaudhary Supra, that the office of a lawyer is not a commercial establishment. Para. Though Mr. Bhattacharjee, learned additional government pleader, placed reliance on the procedure of registration of partnership firm, downloaded from the official website of the Government of West Bengal, providing a comprehensive list of documents for registration of partnership firm. However, upon going through the same, it is found that the list of comprehensive documents of current trade license, though has been noted, but same does not appear to be mandatory. No rules are placed before this court that the trade license is a mandatory document for registration of a partnership firm of carrying on the purpose of legal profession. This court is in consonance with, in reply to Mr. Bhattacharya pore, Mr. Chaudhary reply that Dr. Chaudhary, learned advocate for the petitioner, in reply submits that rules are framed 21. Rules supplements any provisions for which power has not been conferred. It becomes ultra virus. Rule must accord with the parent statute as it cannot travel beyond it. Paragraph. Next step. Continuation. This court is in consonance with Mr. Dr. Chaudhary, relying on S. Srinivasan Supra, that rule must be in accord with the parent statute and cannot travel beyond it. In light of the aforesaid discussion, this court is of the view that the registering authority, particularly respondent number 2, cannot insist upon production of trade license by the firm Messrs. Pinava Legal for carrying on professional practice of law. Accordingly, respondent number 2 is directed to cause registration of the firm, namely partnership firm, namely unregistered partnership firm, namely Messrs. Pinava Legal, within a period of how long it will take? How long it will take? 4 weeks from date of communication of this order. Then within a period of 2 weeks from date of communication of this order. With the aforesaid direction, the writ petition stands disposed of. Petition is directed to serve copy of this order upon respondent number 2, such and such, registrar such and such, for necessary compliance. Disposed. Take this book tomorrow.
Yes, sir.
What do you say, Akun? Where is the other side? He has not come.
I have called it's now not very responsible.
My lord, page 20 is the work order, my lord.
Okay. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent municipal authorities to pay arrear dues of rupees 9,81,790 together with interest accrued thereon to the petitioner from the date of completion of the work till the date of actual disbursement. The petitioner contends that the petition number 1 is a registered government contractor and builder, and petition number 2 is the proprietor of petition number 1, namely Heritage Construction.
My lord, my lord.
Where is the copy of the NIT?
My lord, page 20, my lord. Page 20, my lord, 20.
No, this is work order. Where is the NIT?
My lord, in the work order only it is written, my lord. REF, my lord, the reference after subject, my lord.
When was this NIT floated?
My lord, it was floated. That date is not here, my lord.
Much. The respondent number 3 Mal municipality floated a tender for construction of diagnostic center of Mal municipality at first floor of market complex Uttarapan bracketed Uttarapan at Station Road Mall. No Mall. Kita ki bola? Mall, no?
Mal, my lord.
In response to such NIT, the petitioner submitted tender which was accepted by respondent numbers 3 and 4. Accordingly, work order work order was issued in favor of the petitioner. The petitioner completed the work allotted to him. Upon completion of the work, the petitioner raised bill to the tune of rupees 36,06,927. After much persuasion, the municipal authorities have passed bill for payment of rupees 2625,137.
My lord.
However, the raised amount of rupees 9 lakhs
Yes, my lord. 981,790.
790 is
9
still
lakh
outstanding.
9,81,790, my lord.
Is still outstanding. Hence this writ petition. Mr. So and so, learned advocate, appearing for the petitioner, seeks for specific direction upon respondent number 2 to disburse the outstanding dues of such and such 9 lakh such and such within a stipulated period together with interest. Respond number 3.
My lord, one is the, my lord.
Yeah. 3 will be the person.
My lord.
3 and 4, no? By order dated 13th February 2026, the municipality was directed to take necessary instruction with regard to outstanding dues. 13th bolam date. On 11 June 2026, accommodation was sought for on behalf of the respondent municipality, Mahal municipality. Today, when the matter is taken up, none appears on behalf of the Mahal municipality. Respond number 3 and 4. You have informed. It is informed by learned advocate representing the petitioner that he informed of the matter to the learned advocate for the municipality. Despite such persuasive action, none is representing the Mahal municipality. Ms. Supriya Singh, learned advocate for the state respondents, submits that the answering respondent is the municipality. Para. It is admittedly the petitioner participated in the NIT and the tender submitted by the petitioner was accepted by the municipality. Work order was issued in favor of the petitioner. The total tender bill amount was 36,08,731.
My lord, 36,06,927, the tender amount.
Sorry, 36,06,927.
My lord.
927. The record reveals that an amount of rupees 2625,137
My lord.
has already been disbursed in favor of the petitioner. The outstanding dues is rupees 9,81,790.
My lord.
Such being the position, the petitioner is entitled to the outstanding amount. Accordingly, respondent number 3 and 4 is directed to disburse the outstanding amount of rupees 9 lakh, amount of owner, together with interest at the rate of 8% per annum from the date of completion of the work till the date of disbursement within a period of 8 weeks from date of communication of this order.
Grateful, my lord, grateful.
Useful.
My lord, item 84, my lord, similar matter. Here, my lord, completion certificate was issued in favor of the petitioner, my lord. Item 84.
84 never know. Afterwards. Afterwards, you mentioned we will the next. Sorry. Next.
Grateful, my lord.
30. Service.
My lord, this can be, my lord, disposed of by directing the district inspector of school to consider the representation, my lord. The petitioner is alleging that family pension of his deceased mother was not given to him. At that point of time, he was minor. It is with a representation, my lord, can direct 24 to be considered by the district inspector of school, primary education, Kuch Bihar.
And at the time of death, he is only 16 years old. As per the rules, sir, he is much entitled.
If he is entitled, he will get, let it be considered.
16 years.
Julia Rekalap, yes.
At time of death. Now this, what is the age of the petitioner right now?
At present, he says 33 years.
33.
And when his mother has expired, at the retirement point of view, he is only 16 years.
Family. Nisha Rani Bormo. Donkey. How will he be entitled to that?
Let it consider whether he is entitled or not. If he is not, my lord, a recent order may be passed.
And in terms of the DCR, he is Rule 104, he is entitled to the age of 25 years. So let it be considered by my lord.
Will you say he's 33 already?
He is 33 already, my lord.
Not sir. It's from 16 to 25. Age of 16, from age of 16 at the time of death, he is on 16, and let's say till the age of 25 years, he is entitled for that.
Right now he is.
As per the rules of the DCR. I maybe just permit me hand over. Let's see the report on page 104, and let's the age was clarified in the next page at the top.
দাদা না এই লেজিবল কপি গুলো বলবে স্যার করতে একদম লেজিবল না কোনো টাইম পড়তে পারছি না মানে কিছুই পড়তে পারছি না একটা কিছু পড়া যাচ্ছে না সেই জন্য বুঝি পড়া হ্যাঁ ঠিক আছে ও যদি পেলে পেলো না পেলে
In case of minor son, his son. Until he attains the years, mean which year?
Let's kindly see page next page 43 at the top. Let's see double star mark. Let's see we take it from 18691 page limit for administrative.
By which has raised to 25 years.
That has been considered.
Affidavit of service filed on behalf of the petitioner is taken on record. Present petition, the petitioner seeks for release of family pension in favor of the petitioner with effect from date following the death of the mother. Date following the death of mother. On 25th March 2008. Petitioner contains that his mother was primary school teacher in Baraful Bari Junior Basic School, Bihar. Mother namely Nisha Rani Bormon, who died in harness on 25th March 2008. At the time of the death of his mother, the petitioner was 16 years of age. No family pension was granted to the petitioner upon demise of his mother. The petitioner made a representation on 30th October 2025 seeking for family pension in his favor. Hence this writ petition. However, the same has not been granted, hence this writ petition. Mr. So and so, learned advocate for the petitioner, submits that the petitioner is entitled to, being the minor son of the deceased, is entitled to family pension following the date of his mother till attainment of 25 years of age. He seeks that the matter be relegated to the appropriate authority to take a decision with regard to the representation of the petitioner dated 30th October 2025. Mr. Kunaljit Bhattacharya, learned advocate appearing for learned additional government pleader for the state respondents, submits that the matter be sent to the appropriate authority for taking a decision on the representation of the petitioner. In view of the above submissions, which authority is it?
District Inspector of Schools, my lord, he is respondent number 5.
Respondent number 5, District Inspector of Schools, Primary Education,
Kuch
Bihar, is directed to consider and dispose of the representation of the petitioner dated 30th October 2025 in accordance with law upon notice to the petitioner by passing a reasoned order within a period of 6 weeks from date of communication.
Wait.
Right. No. 5 মিটার কি হবে? আর কি আছে? রাজু বর্মন হলো। It is stop করো। ডাকো।
হলো নাকি? এটা চলে গেল তো।
ওখান থেকে বন্ধ করে দিস, ওটা ওখান থেকে তো বন্ধ করেছে।
না না না, ছোট দেখিনি। আজকে 3:30 বলে ধরলো না, নাহলে ধরে নিত। এটা মারা গেল আর